We want to have our next conversation, which will be around matters of judiciary. Yesterday was our Justice Thursday conversation. We could have had it, yes, but we chose to have another conversation on just training people on what you need to do. When we had lawyer Peter Wanyama, he told us about, the various ways of seeking justice. And one of them is any of the 23 tribunals that we have. One of those tribunals is the Tax Appeals Tribunal. And two members of the tribunal are our next guests. We want to talk about resolving tax disputes. The Honorable Timothy Vikiru and the Honorable Gloria Ogaga are our guests. Good morning.
Good morning.
Good morning.
How are you doing? Welcome to the hot seats of the Kenya's biggest conversation.
Thank you very much.
Karibuni sana. Now, CT would have been seated there. No, he'd have been seated here if you were in. He's not in today, but he normally gives us the proverbs. So he sent me the proverb for the day. Listen to the proverb, give us your interpretation. The proverbs for this week are from the Republic of Senegal. It's been in the news lately. New president, Sonko is a prime minister. I don't know who the governor of the Nairobi is. But okay.
Nairobi, okay.
Yeah, but let's go on. Today's proverb, if you wait for tomorrow, tomorrow comes. If you don't wait for tomorrow, tomorrow comes. Let's start with you, Gloria. What's your interpretation of this proverb?
Well, be prepared. Tomorrow's coming. That's it. Yeah.
Winter is coming. What's yours, Timothy?
I would say that simply means that time would move either way. If you do something, it moves. If you don't, it still moves.
So?
Time waits for no man.
So?
So you better get ready.
Better get ready. Be prepared for the eventuality will eventual.
Exactly.
Eventually. Okay. The Tax Appeals Tribunal. What is it, Gloria?
Good. So thank you so much, Eric and Ndo, for having us today. So we are members of the Tax Appeals Tribunal. We are judicial officers. The Tax Appeals Tribunal, in short, TAT, is a subordinate court under the judiciary. And we hear and determine tax cases which are filed by taxpayers against KRA. So that is what we do, and what we aim to do every time we make decisions is to aim to empower taxpayers, to help them understand tax better so that they can know their tax position and also be better citizens in this country.
How is it established, Timothy?
The Tax Appeals Tribunal is anchored in law, first through the Constitution of Kenya at Article 1, Section 3, which talks about the delegated powers, which includes the judiciary and the tribunal as one of the arms to which Kenyans have delegated power to make decisions. Then that also goes to Section 159, 1 of the Constitution, which talks about now the judiciary and all the tribunals that are there. So pursuant to that, we have the Tax Appeals Tribunals Act, which now guides the formation of the tax appeals and how it conducts its business in resolving tax disputes. Yeah.
Is this under KRA or under the judiciary?
We are under the judiciary. Hii ni mahakama. Hii ni mahakama. Kwa Kiswahili tunaita mahakama ya rufaa ya kodi ya ushuru.
But who appoints the members of the Tax Appeals Tribunal?
The Judicial Service Commission.
Okay. What's the overall? So you've told us, matters of tax, but by the time we're talking about an appeal, it's because there's a dispute.
That is correct.
And the only one authority in this country that deals with tax matters is the Kenya Revenue Authority. Okay. Does it only deal with matters arising from the Kenya Revenue Authority, or does it also go to other bodies that collect taxes and levies, for example, county governments?
Okay, so the jurisdiction of the TAT is established under the TAT Act, and the only respondent in tax cases is the Commissioner of Kenya Revenue Authority. So we only deal with tax laws, and tax laws include Income Tax Act, VAT Act, Excise Duty Act, Miscellaneous Tax and Fees and Levies Act. And we also deal with customs matters under the East African Community Customs Management Act. So we only deal with those taxes and none other. So the only respondent in tax cases is Kenya Revenue Authority.
Okay. Why was it necessary to have a separate tribunal? Because this is clear. Its mandate or its area that it covers is very clear. It is issues arising, disputes arising then from individuals against KRA. But this specific tribunal has been set up just for that. Why was it necessary to have one with those peculiarities?
It is necessary, or it was necessary, because collection of taxes is a very central part of the government's operations, and in the interest of fairness, then it was important that there be an impartial arbiter to oversee the disputes that then arise out of the role that the Kenya Revenue Authority plays in collecting taxes. There before, there was only the internal alternative dispute resolution mechanism domiciled at KRA, but then you see you will not be the judge and the jury at the same time, so it was important to have an impartial arbiter, and that is how the tribunal was formed.
Okay.
To particularly now look at those disputes, and that is why it is called the Tax Appeals Tribunal, meaning that in the first instance, when you have a tax dispute, you still complain to the commissioner. You make an objection to the commissioner and say that this assessment is not proper, is inaccurate, as it were. Then you have your chance to give your reasons, to give your supporting documents. Then the commissioner makes a decision out of your objection. Then at that point, if you disagree, then now you appeal to the tribunal.
When was it set up? And I ask that because then also it would be interesting to know that was it set up as a result of numerous complaints after a decision was made by the commissioner, or because we just know that there would be issues, that's why it was set up? Was it a causal effect kind of thing?
Okay, good. So there have always been local committees to handle tax disputes. And prior to the Tax Appeals Tribunal Act coming into effect in 2016, there were local committees which handled VAT matters, customs matters, and also income tax matters. So the tribunal was set up just to not as a cause of many disputes, but as part of the dispute resolution process. Now, the dispute resolution process is quite lengthy. It starts within KRA. KRA comes and, say, for instance, audits you, gives you a pre-assessment where you respond to those assessments findings, and if they agree with you, then the matter is settled at that level. After that, it's escalated. If you disagree, then KRA can issue a notice of assessment, which as a taxpayer you're supposed to object to if you disagree with it. Then after you've objected and you've undergone the objection review process, which is still within KRA, what you're supposed to do, the commissioner issues a decision which you can agree or disagree with. So this is just part of the dispute resolution process. The Tax Appeals Tribunal is just part of the dispute resolution process, and we are the first court that handles tax appeals after KRA. After us, then we have the other courts that continue with the tax dispute resolution process.
Okay. It's a lengthy and painful process. By the time the tax authority is coming up with an assessment that tells you that you owe us this, it's painful. Okay? And they're taking several measures to start getting you to pay up immediately. It's painful. Then you go into their internal dispute resolution. And if they determine that, no, we are right and you're wrong, it's still painful. So by the time I'm coming to you, Bwana, I have suffered. Is there anything that can be done to make sure that I'm coming to you without having suffered to that point?
We have, to start with, I think, before I talk about what can be done, it's important to talk about what has been done to bring us to where we are. And just to add on what had been explained before, why the tribunal was formed is part of deepening access to justice, making justice accessible. And now the various laws that guide our operations have made it easier for justice to be accessed, in the sense that there are timelines that bind both the commissioner and even the tribunal in the conduct of our affairs. Them as a tax collector and us as a facilitator of dispute resolution. And the need for this is to ensure that neither suffers, neither the government or through the revenue collector or the taxpayer. And in that, our interest is to ensure that every single coin that is due to the government through the tax collector is collected, but no more than what is due should be collected. Not a single coin more than what is due. So the timelines are stipulated in law. If you object to a decision, like you say, when you're given an assessment and you object to that assessment, the commissioner is required to respond to your objection within 60 days, that is 2 months. So it's cast in law. If he delays, then it will be in your favor. So he has to do that within that timeline. And once he objects and you are dissatisfied with that, then within 30 days you should come to the tribunal to now do an appeal at the tribunal. So those timelines are there, and I believe that as the judiciary also continues to expand and grow and put infrastructure and facilities, there will be such a time that then these timelines can even be shortened to make it easier for the taxpayer to
Timothy, in the intervening period, between the time when the commissioner assesses and determines that I owe him, okay, to the time when the commissioner is writing, to the period when I'm objecting and the commissioner is determining whether my objection makes sense to him or not, is he allowed to do anything else? Like attach my property, freeze my bank accounts? Is he allowed to take any administrative action in this period?
The law provides that there are special circumstances where the commissioner may take action. For example, if you say a flight risk, or there's a possibility or a reasonable cause for the commissioner to believe that you would take away the funds from your account or take them out of the jurisdiction of this country and so on, they may then now issue urgency notices to your bankers and so on. But then, as and when these measures are taken, there are remedies in law that if that is done, then you quickly come to the tribunal through an application, and your case would be looked at. So it's always possible to reverse or undo the actions, enforcement actions, if you feel disgruntled by them. So it is not cast in stone that when he takes a measure, that is the end of it. You still have a remedy, and that can be found within. And those applications are given priority at the tribunal, and they are heard and determined under urgency.
Okay. So what we are saying is that I can come to the tribunal before we have exhausted these internal dispute resolution mechanisms with the tax authority, right? For example, tax authority has issued this assessment, and soon after they have written agency notices to the banks and frozen my accounts. Can I jump to the tribunal immediately, or must I go through this internal process first, wait for 60 days, and then come?
Good. So you talked about reducing the pain of taxpayers. So in that reduction of pain, we always hope that taxpayers understand the law. It's our law. They need to understand their obligations as taxpayers. You need to know what you're supposed to do under the law, because it is very, very clear what you're supposed to do. And you also need to understand your rights after understanding your obligations. Now, on enforcement measures, KRA cannot jump the steps, is not allowed in law to jump the steps of tax collection. So before they attach your property or even issue an agency notice to your banks, they're supposed first to issue an objection decision, which can only arise if you've objected to that assessment. Okay? And you need to have objected to that assessment within the timelines. so that you can have the law on your side.
Sorry, can I just clarify?
Yes.
So, incident X has occurred. KRA asks me to pay 1, 2, 3 because I didn't, or as a penalty or something, 20 million shillings over the next however, and we have, right? You pay this you have to pay this because you didn't previously. What you're saying is that I cannot then come immediately to the Tax Appeals Tribunal and say, hey, look what KRA is asking me to do. This is unfair. I need to put in writing, one would assume, an objection to this order that has been given by KRA. In the event that my objection is ignored, or then that the original ask is insisted upon, it is then that I can come to the tribunal. Am I right?
That is correct.
Okay. Now, what is the character of some of the cases that we see coming to the tribunal, and do we have a larger percentage of them being kind of like the same sort of thing?
So we have varied types of disputes. Disputes to do with different taxes, first of all. Then disputes of different natures, such as KRA perceives that you probably did not declare all your income, so they assess you on that basis. Then there's disputes on interpretation of how a transaction is to be handled with regard to tax. Also, there are disputes to do with sufficient documentation to support your alleged transactions. So there are different types of disputes that we see. But what we've come to notice about mainly individual taxpayers and the micro and small and medium enterprises is that there seems to be a lack of awareness about how to handle tax transactions, which is of course under the mandate of KRA to educate taxpayers, but also how to document their transactions. So many cases come to us with regard to sufficiency of supporting evidence.
Okay. So do you take that into consideration then when making a decision? Because if something is being asked of me as an individual, and remember from what you had said, of course you remember because I know, that this tribunal is primarily for individuals who have an issue with KRA. So if what you're saying now, that you've seen that a lot of it is because of lack of information, people don't have the knowledge, and because of that, they get into a sticky situation. But whose responsibility is it to share that information? How am I supposed to document transactions? I can do it because I feel this is the right way to do. But there's an authority who has a way in which they'd like it to be seen. If they don't share that information and they want to penalize me tomorrow, then I have every right to be before the tribunal, and it should actually rule in my favor, should you not, if they've not shared the information?
I think I would also want to clarify before I respond to your question that our mandate is not only for individuals who are aggrieved by the commissioner's
we had already
decision.
agreed that it was for us.
It includes individuals, corporations, and each taxpayer, as long as
All
you are
taxpayers.
a taxpayer.
All taxpayers.
Yes,
Okay,
yes. Even
fine.
the government. We have cases where the county governments have come, or government corporations have come to us so that we resolve their disputes with the
authorities.
KRA, yes.
Okay.
And I would want to say that the old adage goes, ignorance of the law is no defense. So not that the taxpayer is therefore doomed for not knowing what they should have done, and that's why we are saying KRA has the responsibility to educate the taxpayer, but we're also saying that a tribunal such as ourselves is not your ordinary court, as it were, and that is why tribunals are set up, because tribunals are specialized in nature. We have people who are expert in specific areas, like ourselves now. We have people who are experts in tax area and so on, besides having advocates. And the reason for this is that our mandate is not only adversarial like the court system would be, but this is inquisitorial also. We are allowed to now look at the issues at hand, see whether your documentation was sufficient or not, as it were, and weigh in to determine the specific context, because we're also coming from a place where there are traders in the rural area who actually know nothing about documentation. But if you listen to them, give them the opportunity to come and present their case orally or otherwise, then you are able to make a just determination of whether indeed there are taxes that are due or not.
Does the tribunal have the mandate to actually mandate KRA to conduct awareness? When you realize that many of the cases that are coming here are from taxpayers or involve taxpayers who don't have sufficient awareness on tax matters, and that this is a problem, are you mandated to actually tell KRA, listen, you must conduct this kind of awareness in a manner that demonstrates that people are understanding?
No, we don't have that mandate. Our mandate is strictly hearing and determining the appeals that are before us. I believe KRA is a very competent government agency, and they're well funded with regard to taxpayer education. So we cannot order KRA to train and educate taxpayers. It is not in our mandate.
Can you raise it with them? Can you put it there? Like, it's come to our notice that this is happening a lot, and it's important that you, KRA, then now go further with your education.
Yeah, there is fora for that kind of escalation of the issues that we come across when we are conducting our business. For example, is through the Tribunal Users Committee, which is an initiative of the judiciary, which brings together the users of the tribunals. Now here you're talking about the Law Society of Kenya, KRA, ISPAC, and that is for the with specific reference to the Tax Appeals Tribunal and the other tribunals also.
National Joakali Association.
Exactly. The taxpayers and the tax agents and individuals for that matter who are taxpayers, and through that kind of fora then we make our recommendations that are based on the findings that come across when we are conducting our work.
Okay. Our guests this morning are members of the Tax Appeals Tribunal, the Honorable Gloria Ogaga and Honorable Timothy Vikiru. People are having a conversation online. Why are these people calling themselves honorable? You want to answer that, Timothy, before we take this break?
Sure.
Why are you Honorable Timothy Vikiru?
You see, when you are a judicial officer presiding over those matters, that is the position which you are given.
That's the title of the job.
Law. Yes, the title of the job.
Okay.
Yeah.
Okay. So you get it, Paul, and everybody else? That's
why.
Yeah.
So you've just taken us through that process. So the KRA may look at what you're filing in your tax returns and determine, no, maybe you have underdeclared. And then they assess you and they say, no, from our assessment, this is what your income was and this is what you ought to have paid, or several other issues. So you're saying the process is they will write to me and say, dear taxpayer, we noticed this and the other. You owe us this amount of money. Pay. Okay? And so what should I do thereafter, Gloria?
Okay, good.
Immediately I receive that email or that communication from KRA, what should I do immediately?
So typically, KRA would issue such a letter, and that would normally be before they issue a formal assessment. So they would just be informing you that we have noticed that you may have underdeclared some income, or you may not have paid all the taxes that you ought to have collected and remitted to KRA. So what you ought to do at that time, you're supposed to respond to that letter in a timely fashion. You're supposed to respond to a pre-assessment, and KRA would respond back by giving you a notice of assessment, which if you've agreed during that process of the first review that if they disagree with you and your response, then you ought to object to that notice of assessment within 30 days of receiving that notice of assessment. If by any chance you are late in objecting, then there is room for you to seek extension of time to file your objection. And if the commissioner agrees or allows you to file it, then they would accept that objection and review it. And KRA is required to give a decision on that objection within 60 days. Failure to which your objection would be deemed to be allowed as you had filed it.
Okay. What should my objection look like? Can I just respond and say, I disagree?
No.
Or Kwendenyuko?
No. No, that is not sufficient. So what you ought to do as a taxpayer, you're supposed to, one, understand your taxes. If you disagree with the position for good reason, you ought to state why you've disagreed with that decision, what amendments you require KRA to make on that initial assessment, and you're supposed to provide all the documentation to support your claims of your tax position. So once you've filed all these elaborate documents with KRA and you elaborate what your case is and you articulate it, KRA are supposed to consider all this information.
Mm-hmm.
They're supposed to consider all this information. So articulation of your tax position is so critical in the tax dispute resolution process so that we avoid a situation where KRA has misunderstood you or misunderstood what you've said or misunderstood your transactions.
Yeah. So they write to me with a notice first. I object. By objecting, I file all the information that I need to.
Yes.
But this should be within 30 days.
Correct.
Ideally. And then thereafter, I get a response from KRA. At this point, you've not even started going into internal dispute resolution yet.
That is internal.
Or this is it.
Correct.
This is part of the internal dispute resolution.
Yes.
So if I submit an objection within a week of their first email, by when should I receive a response from KRA?
So once you file the objection, KRA ought to give a decision within 60 days. In the meanwhile, as a taxpayer, you have a right to be involved in the objection review process.
Okay.
Participating in the objection review process can enable you achieve maybe your desired outcome or even seek clarity as a taxpayer so that you can be educated on what the correct position is, such that by the time the objection decision comes, you are in agreement with it because you've sat with these officers and they've explained to you what the position is, you've explained your part, but if maybe you had misunderstood the law, then you're educated at that point and you agree with KRA that this is my correct tax position.
Okay. During this period, the position remains the same. I am still allowed to trade and earn an income and continue filing as I have been filing, right?
Yes.
Or should I be making changes at this point?
No, the status quo ought to prevail,
Okay.
because you are in the process of now confirming whether tax is due or it is not due. So that should not hamper your conduct of your own of your business,
Okay.
as it were.
Okay.
It is in the interest of the authority for you to continue conducting business and generate more taxes that would be payable. What I would like to add on that process, a lot happens during that internal dispute resolution within KRA. So when you do your objection decision, the law is very clear in the Tax Procedures Act of what should be contained in that objection decision, which she has very ably explained. In the event that your objection decision does not meet that requirement of the law, it is the responsibility of KRA to write to you within the stipulated period. There are also timelines for that and tell you that your objection does not meet the threshold or it is invalid for that matter, and give you an opportunity to validate it. And they would always give you the timelines. So what is more important is to observe the timelines that you're given internally by KRA during that period. What we have also seen in practice is that a lot gets determined during that process. However, there remains other issues that remain undetermined. The case is that you don't start with 1 billion owing and always end with a billion. Sometimes you realize during that process you've knocked off quite a bit of this. Like she says, you've justified to KRA that this is not income, this is my own money I deposited, and those kind of things. And there remain sticking issues. And you'll find that in the objection decision they tell you, we have now looked at this and decided it's not a billion, it's actually 10 million. But you still think this 10 million is not due to KRA. And that's the point at which you object. And important to say that internal process is very important because what invokes the jurisdiction of the tribunal is once you have complied with the internal processes at KRA, then you now come to the objection decision and you come to appeal. So sometimes you would come to us prematurely, like you're saying, when you panic and you get a letter from KRA and you come to the tribunal, you will realize that we will tell you have not exhausted the internal remedies. You must follow that process. So it's very important for taxpayers to acquaint themselves with the various tax laws that govern the kind of businesses they conduct, because there are various tax laws depending on different businesses that you conduct.
So the assumption is that by the time you've come to the tribunal, all of your I's would have been dotted and your T's would have been crossed, that by the time you're coming, everybody has done what they're supposed to do, but you're still at an impasse and you cannot agree. What are the possible outcomes of the tribunal? What could it be? You can be vindicated, KRA can be whatever. Are there a number that can there only be 3, for example, decisions that would come out from proceedings at the tribunal? What would be?
Okay, good. So there are 3 scenarios that can play out when we are making our determination. So either the taxpayer can win, or KRA can win, or having considered all the documents that have been filed before the tribunal, we can refer the matter back to the commissioner for them to consider the information that we may have determined that the commissioner did not consider but was before him, to consider that information and make a proper objection decision. So we don't tell the commissioner that in your objection decision, decide like this. We need the commissioner to make a decision. When we refer back, we need the commissioner to consider the information before him and make a proper decision.
There is also another very preliminary outcome that you would have, apart from the 3 that she has talked about, and this is anchored on procedure, because in terms of tax law, procedure is very important. So if either of the parties has not followed procedure, it would be injurious to them, but also it would be such that it denies or negates the jurisdiction of the tribunal. And in that case, then the case would be struck out. And when it is struck out, it means that you have the opportunity to come again, but now in accordance with procedure.
Come through the door, friend.
As
You're
opposed to the
not the window. Okay. So this process is about 90 days, isn't it? Okay. Because the internal dispute resolution mechanism is about 60 days. And then after we come to the tribunal, within 30 days, the matter should be concluded. Am I right?
That is not correct. So what happens after the objection decision has been issued or refund decision? There are a number of appealable decisions that come before us. A taxpayer ought to file a notice of appeal within 30 days of receiving that decision. They're supposed to serve the commissioner with this notice and also file that document of notice with the tribunal.
Okay.
After that, 14 days later, the taxpayer ought to now file the appeal. So they pay a filing fee of 20,000 shillings to the tribunal and file their appeal, which should be in the memorandum of appeal stating the grounds of appeal, and filing their statement of facts stating what the facts were, and attaching the documents to support these facts. After that, then the pre-trial process starts. And the commissioner ought to file their statement of facts again within 30 days of being served with the appeal. So after that, pre-trial starts, and the taxpayer has a right to settle the matter out of court. So it's a voluntary process called alternative dispute resolution. It is currently housed at KRA. So if KRA and the taxpayer agree to consider settling the matter out of court, they ought to make an application to the tribunal, which we allow, and then they have 120 days to come to an agreement. And within that 120 days, once they come to an agreement, they're supposed to inform the tribunal of what they've agreed by way of consent. And if all the matters have not been agreed to with regard to that consent, then the tribunal is to determine the matters still in dispute. And we are supposed to determine these matters within 120 days. from the initial 120 days of ADR.
Okay. So from the initial ADR, from the moment you send us to alternative dispute resolution, you start counting your 120 days.
Our days start counting after the 120 days of ADR.
Okay. So this process has, 30 days, 14 days, 30 days, 120 days, another 120 days. It's a long process. How many months are we talking about? So realistically, how long, if the commissioner has responded to my objection and said, your objection is moot, and then I file that notice that I am going to the tax dispute tribunal, how long should I give this?
Give or take between 1.5 to 2 years.
Okay.
Yes.
In the intervening period, what happens? Are we still on status quo?
Yes, we are still on status quo. You are expected to continue paying the taxes, especially the taxes that are not in dispute, must always continue to be paid. In fact, for you to even make a complaint, you must show that any tax not in dispute has been paid. So in the intervening period, as your dispute is being determined, everything else should continue as it were before. Okay. Because now collection cannot be done because these taxes have not been confirmed as being due and payable. However, those others that you have been paying, which you yourself agree to, must continue to be paid even during that period.
Okay. And so KRA cannot take any action. I'm coming back to that thing. So with this 2 years, from the moment I told KRA to Patane Mbele, they cannot take any other action on this particular issue with this particular disputed taxes.
Now that is anchored in the procedures of the tax dispute resolution, particularly in if it is income tax, VAT and so on, is anchored in the Tax Procedures Act. Then if it is customs, there is the East Africa Community Customs Management Act. So it is not a yes or no answer because there is procedure that you have to keep abiding to. So if you fail to abide to a single process, then the whole thing changes. So we would not also want to give that perception or that comfort or illusion to the taxpayer that once you arrive at our doorstep, then you should sit pretty and wait for your determination at the end. You are supposed to also be complying with the steps that are within that process, and that is the only way now you will be sure that you'll go the whole journey and get your determination at the end without having suffered.
There's an imbalance of power here.
Yeah.
Because I'm seeing that KRA will determine that, oh, no, you flouted this procedure, so kapap, agency notice, freeze your bank accounts, and then we have to come to you again to start arguing that, they are saying that I've flouted it, but...
If I can jump on that, because it seems as though the point of reference for all of this still remains KRA, that you will still go back to the authority to say, well, actually, Ndu is disputing 1, 2, 3. You are the one we're going to come to ask and make sure whether actually they are in line. So it's almost as though you don't stand a chance from the very beginning, because it will be KRA who will say, well, actually, no, this is what it looks like. Because they continue to be the point of reference. Can I, as an individual, not be the point of reference if all my documentation, like what Mary Gitari is asking here, if all my documentation is correct, can I not be a point of reference where I tell you, actually, you know what? I have paid. I'm exempt because of 1, 2, 3. I understand the law. I've done what I'm supposed to do. Can't I be a point of reference? It seems as though in this, there's Big Brother and me, and we're supposed to all be on the same page when it comes to this tribunal. But you're going to keep going to Big Brother to ask, well, actually, have they? It seems as though there is an imbalance.
Not quite. Huh? What should be clear for starters here is that KRA is mandated by the law to collect taxes. And you, as a citizen abiding by the laws of the country, you should pay the taxes that you are obliged to pay.
Yes.
However, the background of this is that it is you who does your business, and it is you who has all the documents concerning your business. The authority does not have that privilege of having your documents other than when you provide them. And that is why when it comes to tax matters, the law says that it is you, the taxpayer, to disprove the commissioner. When the commissioner makes
the burden of proof is on
the
me.
burden of proof is on you as the taxpayer. And the reasoning behind that is that it is your business and it is you who keeps the record and everything, and you know all that goes on. So this authority just comes to your place, probably does an audit or analyzes online whatever you have filed, and based on whatever information they have at that point in time, then they have to make that determination that you owe this.
Right.
And then that's where the dispute begins. So in this whole process then, there will be tax that is in dispute and that is not in dispute. Because again, you could it would not be possible for you to say that you are conducting business and there is no tax that is that is due unless you have sought for the exemptions where they exist, as it were. So there is not an imbalance of power,
it just
but
seems
it is
as though
only
KRA comes into the race wearing two shoes and everybody else comes in barefoot. I mean, that's the way it seems. That's the way it seems. Is there ever a case where KRA is in the wrong? Ever? Whereby an individual is clear that here there was an issue and KRA is the one now who is at fault, as it were. And in that case, what happens? Or we just say, actually, you know what, KRA is at fault, okay, this thing, forget it, out the window, and then we just carry on? Or are there damages then that can be seen by the individual who was wrongfully penalized?
Either there is tax in dispute or there is no tax in dispute.
So we go through the tribunal for you to say
now,
there's no tax in dispute, everybody goes home?
No, I'm still explaining.
Sorry.
Now, if tax that was not in dispute has been collected, that tax must be refunded, and we will order for you to be refunded, and in a stipulated time. We'll say within 60 days, we'll say. So we will ensure that you are restituted to the correct position, as it were,
with interest and penalty.
That is now not the mandate that we execute at that point, because we don't go into computations of any nature as to the penalties that are accrued and so on. We deal with the tax that is in dispute, because the law now talks about everything else in terms of the penalties and so on. They fall into place. Once we make our determination, now the law falls into place as to what is due either as a refund to you or due payable to KRA. And your question was, is there a point in time when KRA is wrong? And I would say 1001. There are replete decisions out there that you could look at that we have found the tax collector being wrong, either procedurally or also substantively, having failed to understand the taxpayer to that extent.
So, back to this. In these 2 years, when we are, coming to the tribunal, we want an arbitrator to look at this dispute, because we are in dispute. I'm still paying the taxes that are not in dispute. What happens to the issuance of a tax clearance certificate and such? Should KRA give me a clean bill of health with a tax clearance certificate, or should they not?
Okay, so on matters that are in dispute and before the tribunal, the taxes are suspended. KRA cannot collect them. If you get an agency notice, if your bank gets an agency notice with regard to that tax, you make an application to the tribunal, and we order that the agency notice be lifted.
Okay.
Now, with regard to
TCC.
tax compliance certificates,
Compliance.
this is within the mandate of KRA. We do not make orders on decisions on tax compliance certificates. We do not do that because my understanding is that tax compliance certificates have a statement where it says that you have filed all your tax returns and paid all the taxes that are due to the satisfaction of the commissioner. So what I would implore taxpayers to do is to deal with KRA, to participate in this tax process. We are all under the law, and KRA has officers who are people. You can go and make your case and ask to be allowed a tax compliance certificate. So it's still within KRA, but taxpayers need to understand that they can approach KRA and ask.
No,
for
we're in
such
dispute,
documents.
Bwana. This guy is unapproachable. And that's why we have come
we're
to
here
you.
in the first place.
And in the meantime, I need a tax compliance certificate.
Yeah.
and they're not issuing. Reason best known to them, and we all know what those reasons are. That's why we are in front of you. I mean, can't you order them to give me
No.
or tell me what other dispute there is?
In terms of resolution of tax dispute, the mandate is very clear. There are cases where you would have issues with KRA that do not amount to an appealable decision before the tax appeals tribunal, because the law stipulates what an appealable decision is. Now, if you have an issue that regards the commissioner but is not an appealable decision to the tax appeals tribunal, then you can seek for judicial review, and you can approach the other courts to determine that. And they will not have an issue with you because you would have clearly stipulated that this is not within the purview of the tax appeals tribunal. So there are cases which get to the other courts, as it were, that regard the revenue authority and don't necessarily come to the tribunal. But we cannot determine anything beyond our mandate, which is to look at the appealable decisions made by the commissioner.
Okay. Thank you very much for joining us today. We've learned quite a bit. Yeah, you want to make one final point?
One final point, yes. So we do understand that the public may lack sufficient knowledge about the Tax Appeals Tribunal. We want to create this awareness so that taxpayers can have better access to justice. So in addition to us making media appearances and discussing the Tax Appeals Tribunal and the tax appeal process, we will be going to the ground. We intend to go to 4 regions in the country so that we can reach taxpayers on the ground. We explain what our mandate is, the tax appeal process, their obligations in the tax appeal process, and the tax and their rights.
Your life.
Tax appeal process. So we intend to go to Mount Kenya region from next week, Monday. And after that, we will go to the coastal region. And in May, we'll go to Western Kenya and Rift Valley to meet taxpayers and educate them on the tax appeal process. With us, during the sensitization, we'll have KRA, which will explain the alternative dispute resolution, and so that the taxpayers can understand that there are various levels of legal redress with regard to tax disputes. So we are looking forward to meeting taxpayers out there starting next week, and yes, and we hope that we'll have an impact with regard to your comfort that tax decisions can be addressed legally and fairly.
Thank you very much. That's the Honorable Gloria Ogaga, who's a member of the Tax Appeals Tribunal, alongside the Honorable Timothy Vikiru.
This is the Situation Room, the only way to start your day.